Hi, I'm Brian Walters from Walters Gilbreth, and I wanted to answer some questions today about depositions. We get a lot of questions about those. What are they? Are they necessary? What do they do? What's the purpose of them? So I'll go into all that and keep sending us questions. We enjoy answering them for sure. So a deposition is a formal sit-down question and answer session in a lawsuit, including a family law case or a divorce case. Typically it takes place in one of the attorney's offices. There's a person asking questions, that's usually the attorney on the other side, and then there's a person answering questions, which is the person usually that's on the opposing side. We notice them, we send them a formal notice of it. It can be agreed or it can just be something that's forced, and then the person either shows up by themselves or they can be required to bring certain documents with them. And then we just start answering questions, which sounds real simple, but of course it's not quite that simple. There's a couple different types of depositions, I'd say. There's the kind of quickie ones that you want to do, and sometimes in a case that are just a way to establish basic evidence and information. Then there's the much more longer or sophisticated ones. Those are typically limited to about 6 hours of questioning, basically a full day of questioning. There can be depositions of people that are in the case, a husband or a wife, for example. Also, there could be depositions of witnesses for whatever form they might take, a neighbor, a friend, a girlfriend, a boyfriend, something like that that might be relevant in one of these cases. And then there's also expert depositions where there's an expert witness in a case and they get asked questions. That's a little bit of a different process with some additional things that are required in it. So I'll go through those in time here, but essentially what you're doing in a deposition is you're getting under oath the testimony of somebody. And the reason that's important is that, first of all, you can either find out things that are not in question, in other words, things that we all agree on, therefore we don't need to spend time in a lawsuit trying to prove something that everybody already agrees is the case, or you may find out things that are disputed. And if they're disputed, let's say you were arguing over the value of a business. Well, okay, there's a dispute over it. What, the questions would be along the lines of, well, what do you think the business is worth? Well, $3 million. Well, that's not what we think, so tell me why. How'd you come up with that number? How sure are you of that number? Those type of things. Those are the two major reasons you do a deposition. The other nice thing about them, I think, especially early on in a case, is that they tie people down with their legal positions. So if somebody says, let's say that $3 million is the value of the business, it's going to be difficult for them a year later unless there's been some major intervening event to change their story. Or if they say, if you ask them, have you cheated on your wife or something like that, if they say yes, it's going to be pretty difficult for them to later say, well, actually, I didn't mean that. No, I didn't. Or if they say no and you can later establish that they were cheating, then you've caught them in a lie, and that's a problem for them in the case. So typically, you might want to do a deposition fairly early in a case, especially for that first purpose of trying to figure out what's there that we agree on. To a second degree, what do we disagree on? Sometimes early in a case it can be difficult for people to be certain about things. I'll go back to the example of the business value. Somebody might say, look, I don't really know what the business is worth. I need to, more documents, or I need more information. So something along those lines. So what does a deposition look like? So, and again, these days we'll sometimes do them by Zoom. That's become more frequent, but I'd say a majority of them are still in person. Prior to COVID, they were probably 99% in person. It just kind of depends on the situation. So again, to back up on the procedure, let's say I'm representing the husband in a divorce and I want to take a deposition of the wife. I've got some questions for her. So I'll first of all talk to my client and say, do you want me to do this deposition? Here are the pluses, A, B, C. Here are the minuses, C, D, E. And if the client says, yeah, let's go ahead and do the deposition, then we'll set that up. So then what I'll do is I'll email the other lawyer for the wife, and I'll say, look, I want to take your client's deposition. Give me some dates in June, for example. I need a half day, let's say. Typically, they'll write me back and say, I've got June 12th or 13th or something available, and we'll agree on a date. I'll send out a formal notice, pretty simple document that you put together that says, you need to be at my office, at 9 o'clock on June 11th, and if I want them to bring documents, and I need to be specific about that too, and I need to give them a little more time. I technically don't have to give them much time if they're just going to show up for their own deposition, but if they're going to bring documents, I'm supposed to give them a longer period of time to do that, which makes sense, right? If you're going to have to dig up certain documents, especially a lot of very specific documents, then you typically need to give somebody more time to do that. So just kind of depends on whether you want those documents there at the deposition or not. If you're in a hurry, you probably don't want the documents and you just want to get the deposition done. So then the day of the deposition rolls around, they come into our office. It'll be, in this case, the wife with her attorney. There'll also be a court reporter here. That's a neutral person who will write down in certified shorthand exactly what they're saying and then eventually produce a typed up deposition transcript which shows everything that's been said in it. Sometimes there's also a videographer. If you want the deposition videotaped, you'll have a videographer show up with video camera and lights and all of that kind of stuff. It just depends. Typically we don't use video. It's an additional expense and it's might be useful, it might not be. It really kind of depends on the budget in the case and how important we think the information may be. So then the deposition starts, and generally what happens is I'll ask questions for about an hour. I typically start with really basic things, who are you, when were you born, what's your driver's license number, all of those kind of basic things, and then we get into specific topics. I either typically proceed by a timeline. I found that's sort of the easiest way to follow information, or by subject matter. So for example, if we are looking at the value of a business, I might talk about, just have a series of questions about the business and when it was formed and what it does and revenue and profit and all of those kind of things. So usually one of those two things. I usually, in reality, do something in between where I have a timeline, and then when I hit on a timeline a specific topic, I'll often then go down on that topic for a while before coming back to the timeline. That's generally the way I organize depositions, but it just also depends a little bit on what you want and what you're after in the case. It also depends a little bit on how responsive the person being deposed is. They're supposed to listen to my question, which is supposed to be a very specific question in a very specific format, and then they're supposed to wait a second and then answer my specific question. Sometimes people aren't like that. Sometimes they don't want to answer the question, which they're really essentially not allowed to do, or they won't be direct about the question, or they'll try to answer what they think will be two or three questions ahead. And so if there's any dispute like that, you can record that in the deposition of, hey, you're not answering my question. Generally, the other lawyer will instruct them to say, yeah, actually, sorry, you do need to answer that question, or not. I mean, sometimes you disagree and you have to go see a judge later about that disagreement. It just kind of depends. But I haven't had to do that too often. Usually it's fairly easy to figure out what needs to be answered in a deposition. And it can be pretty uncomfortable sometimes because it is pretty broad. I mean, let's go back to that adultery question that we talked about earlier. You can get into some very specific questions about, with who, where, when, what happened, describe the details. I mean, it can be pretty gruesome. It's the same thing if there's very unpleasant issues with child custody or substance abuse or mental health or family violence. Sometimes people take the Fifth Amendment in those situations, and so these depositions can often cover some pretty emotional, pretty heavy stuff. Typically, if I'm taking a deposition, I take about an hour to ask questions, and then I'll take a break. People want to go to the restroom or have water or whatever, but mostly I want to go over with my client to step outside into my office for a few minutes and say, okay, I covered these topics, these 3 out of the 5 topics in the first hour. Do you want me to go over anything? Did I miss anything? Is there anything that, any issues that she kind of glossed over that we need to come back to? Those kind of things. Then we'll come back in, I'll do another hour, take another break, and generally go like that. If we're going all day, we'll typically take a lunch break too. And until my client's satisfied and I'm satisfied that we've asked all the questions and gotten all the answers that we want to. Now, technically, the other side at the end of my questioning can start asking their own client some questions, but that's pretty rarely done because actually the purpose of a deposition, when your deposition is being taken by another lawyer, the purpose is actually to give them as little information as possible within the rules, right? And me as an attorney taking a deposition, I want the opposite. I want as much information as possible. So once I finish asking my questions, I can't ask any more in the deposition, and so the other lawyer, unless the other lawyer sort of opens the door to it, and so if the other lawyer starts asking them questions, then sometimes additional information comes out that's harmful. Sometimes additional information comes out that we had no idea about and sort of opens up a can of worms. So most of the time the lawyer will not ask their own client any questions. I've seen some exceptions to that, especially if they really are trying to kind of prove that they're in the right, and I think that my questions have been sort of misleading or only asking about one side of the story. I've seen people try to do that, but again, that's generally not what happens. And so eventually the deposition will end. Also, I should add, if there's documents, then I'll ask them to give me the documents, review them, and then we can talk about the documents. Sometimes people don't bring documents, or they don't bring all the documents, or they bring altered documents, and so that can get pretty interesting about documents. But generally speaking, it's a pretty straightforward situation, and a lot of times I'll have the documents ahead of time so that I don't have to kind of review them live at the deposition. It just kind of depends on the specifics. Anyway, once the deposition is over, then everybody leaves. The court reporter takes a week or 2 or 3 to get the transcript together, circulates it around. The person whose deposition was taken has a little bit of time to review the transcript and point out if they think there were any errors. The videographer does the same thing. They transcribe or they edit the video so that it's showing it, and it lines up with the court reporter's time and notes. So about a month after the deposition is completed, there's kind of a final format of it. And then it becomes history. There's really not much you can do about the depo after those timelines have run. You can use them in the future if you need to. If you can use them in court, for example, I could, back to the question of the adultery, if I asked somebody, did you cheat on your wife? And they said no back in March, and then we get into trial, 6 months later in September, and they say, and now I've got evidence that they did, and I ask them, did you cheat on your wife? And they say yes. Well, I'll say, well, that's not what you told me back in March, is it? You lied to me, and you told me that you hadn't. And they're going to then have to essentially admit, yes, they lied. And that never looks good in a courtroom. The judges really, really dislike that. Our court system is actually based on the concept, sort of like our tax system, that most people are going to be honest and straightforward. And like our tax system, family law, probably that's an assumption that's a bit overly broad, and that people aren't so honest as it turns out, especially for sensitive things, money, sex, even child issues or substance abuse, mental health. People can be very reluctant to discuss those things, either an outright lie or just simply be in denial of what other people would consider reality. And so it's good to be able to use that, because when you get in a courtroom, you certainly want to harm the credibility of your opponent. If the judge is trying to figure out what happened in a case, a lot of times, let's say it's a child custody case, and mom says, well, I did most of the child raising, and dad said, well, I did. Often there's no real way to prove that, but if mom, let's say in this example, lied about 3 or 4 things in her deposition, and dad has been completely honest, well, the judge may conclude, well, then, I don't know exactly who to believe, but mom's not very honest about other things, so there's a good chance she's being dishonest about this. Therefore, I'm going to believe dad. So that's sort of the theory behind it. I've found depositions to be a really good tool. It turns out most people don't like being deposed. They don't like this situation where their spouse's attorney gets to ask them all these questions, which they don't get to respond the way they want to. They don't get to tell their side of the story, essentially, and it's a very unpleasant situation for them. It often brings people to the negotiating table. By the way, that's what trial's going to be like for them, except considerably more stressful. Court is not like on TV a lot of times, where you kind of get to give a speech and the judge believes what you say, and the judge vindicates everything that you believe in. It typically doesn't work like that. It certainly doesn't work that you get to give a speech. You get to just answer questions from lawyers, which is not an ideal way to get your whole story out, especially if the other lawyer's asking you questions. So I've also found it a cost-effective way to get certain information quickly and cheaply. Depositions can be a lot quicker and cheaper than doing written discovery, which if both sides cooperate, written discovery is probably quicker and cheaper, but a lot of times people don't, or they're not cooperative about the things that they are uncomfortable with sharing. And so if I just sit someone down and I just ask them a bunch of questions about their business and their finances and their bank balances, I can get the financial information usually much more quickly and easily than I can by written discovery. Depositions can be fairly expensive, though, because you do have your lawyer sitting in there for hours at a time, and they have to do preparation. You've got a court reporter and maybe a videographer. You can cut down on some of those expenses, but not all of them. So it's a plus or minus. I'd say generally depositions are in larger, more sophisticated and complex cases rather than just the day-to-day cases. So that's my view of depositions. Again, I find them interesting. I've found them easier to do also with people doing them by Zoom. If you have a witness that's out of town, or if a case is out of town from where I live that I'm on, it's easier for me to appear by Zoom than flying somewhere or driving somewhere and then showing up a lot quicker and easier. And I think it's just about as effective either way. I don't think it makes too much of a difference. There probably is some small value to being in person with somebody, and that would be, I think, necessary in certain cases to do. So that's my summary of depositions. I hope that's helpful. Please continue to ask us questions and follow up and comment, and we'll go from there.